the federal government was surveilling our citizens. And rather than be more and more heartened by and assured by the processes that were underway, I became more and more concerned about overreach, about federal officials and trying to protect us, were basically denying and breaking faith with the Fourth Amendment, which is an important part of our freedoms. Frankly, if you think about it, the right to privacy, which the Fourth Amendment protects in many, many ways in the short paragraph that makes up the Fourth Amendment, really underlays and supports and buttresses all of our other freedoms, whether it's the freedom to assemble or the freedom to petition our government, the freedom to speech, freedom of religion. If there's not a sense that those matters that are really personal are also private, unless we indicate otherwise, those freedoms can really be threatened and at risk. It made sense to get together today because this is the 20th anniversary of the enactment of the Patriot Act, which was well-intentioned, and there are provisions in there that make sense. But if you look at the history of the application of the Patriot Act, there have been many cases where there's, I believe, and many others in the right, the left, and the center of our political spectrum, overreach on the part of the federal government. So today is an opportunity to consider where we are with the state of surveillance and the actions of the intelligence community in our country and frankly around the world, and look at ways in which we can constrain those powers in appropriate ways, and also understand the history of why we are where we are today. I joined the Fourth Amendment Advisory Committee, and I'm really excited about the work we're doing in many respects. One is that many of us sit on different points of the political spectrum, but we all agree the Fourth Amendment and the right to privacy is key to our freedoms as Americans. And perhaps the work we do can provide an example for other parts of our political world to find ways to agree in the end that we're all Americans and that we all share common values in this particularly divisive time right now. Let me leave you with this final thought. The Revolutionary War that we fought had many causes, but at the core, I believe, was that we all thought that we could do a better job with our own affairs and governing ourselves than the king and the power structure in the United Kingdom could. And so that war ensued, and we are today where we are in part because of standing up to the king. At that time, the king, although he'd been constrained by the Magna Carta and the development of a parliament, still had a lot of unrestricted powers. And in one of those areas of power that the king had included the fact he could seize your property, take your money, in fact, take your life if he so desired. But maybe even more precious, he could take our freedoms. And the Fourth Amendment was designed to protect those freedoms and to ensure that no individual or no government could conduct unreasonable search and seizure. So this is a righteous cause. It's one that I'm excited to be a part of, and look forward to hearing what you learn and conclude today.
Thank you very much to Senator Udall for sending that along. As you all know, he's the former senator from Colorado and stays engaged on these issues. I think all of us here are thankful that we get to work with him every once in a while on these issues. I'm going to quickly go over who is on the panel, and then I'm going to turn to Representative Goodlatte for another introduction. And I'll quickly plug the Secure Liberties newsletter. So if you're interested in these issues, please join the Demand Progress Education Fund newsletter called Secure Liberties. And you can do that at secureliberties.org or on any of the emails that I've sent to, I'm sure, many of you too many times. Okay, with that said, I'm looking forward to talking to everybody. We will have former Virginia Representative Bob Goodlatte, who's also former chairman of the House Judiciary Committee and currently the senior policy advisor for the Project on Privacy and Surveillance Accountability. Sandra Fulton, who's director of surveillance and free expression policy at Free Press. Carolyn Iodice, senior counsel at Clause 40 Foundation and former legislative director for Justin Amash. And Laura Moy, who is the director of the Communications and Technology Law Clinic, associate director of the Center on Privacy and Technology, and associate professor of law at Georgetown Law, because one job is not enough for Laura. With that said, though, I want to turn to Representative Goodlatte. Congressman, thank you as always for joining us. Thank you again for all of your work that you do on these issues. I honestly just want to turn it over to you before we get the whole panel discussion going for any opening remarks you might want to make. Oh, and you're muted.
And thank you for reminding me of that. Thank you, Sean. It's a great opportunity to be here with all of you. It is always an honor to be with, even though not contemporaneously, with my good friend and former colleague, Mark Udall. And I want to also mention that the Project for Privacy and Surveillance Accountability, which is a nonprofit organization, a 501c4. And so we lobby on these issues. And you, in fact, some of you have probably already heard from me or others in our organization. But we also have a newsletter, and you can check that out on our website, ppsa.org. And I hope you will take the opportunity to sign up. Demand Progress and PPSA are co-hosting this event, but we work on a weekly basis with several other organizations that cover the political spectrum, including Free Press, represented by Sandy on this call, and Clause 40, represented by Carolyn, but also Freedom Works, the American Civil Liberties Union, the Brenner Center for Justice, Americans for Prosperity, Due Process. As you can see, quite an array of organizations, all concerned about protecting the privacy and the Fourth Amendment rights of American citizens. And this is a perfect time to talk about it, because what's going on in the country right now is sort of a transition based upon some events that occurred last year. And we'll get into some more details about that later. But one of the bills that we're going to talk about today, and I'm particularly keen on, it's called the Fourth Amendment is Not for Sale Act. This is legislation designed to stop government agencies from being able to purchase data that they would otherwise be required to have a warrant to obtain if they were going through the legal process. But they have found a very convenient loophole, and end around, if you will, of simply buying the data from data brokers and others. And that legislation is vitally important, as you'll see from what has occurred over the 20 years since the original passage of the USA Patriot Act. I also want to call to your attention the opportunity now that some appropriations bills and the National Defense Authorization Act and the Intelligence Authorization Act are up for consideration, and hopefully some or all of those will move in the near future, that amendments to those pieces of legislation would be very, very important to look at and consider supporting, encouraging your member of Congress, the senator you work for, to support. And finally, as you may glean from this panel and from the array of organizations that I just cited, this is a very bipartisan issue area. It's a real opportunity at a time when partisanship is at its peak in the Congress, for members to show some accomplishment for their citizens, for their constituents who are concerned about their privacy, are concerned about government surveillance, to work together. And it's also worked very well across the aisle as well, between the House and the Senate. So we think this is a key opportunity to move forward, and I look forward to participating in this panel.
Thank you so much, Congressman Goodlatte. So that's a perfect frame to open up this discussion. But I also want to turn to our three other panelists, Carolyn, Laura, and Sandy. I'm going to say in that order. I want you to just start us off with one thing that you think everybody in the audience should know going into this discussion. So maybe they know it, maybe they don't, but they need to know it for whatever conversation we're about to have. Carolyn, why don't you go first?
Yeah, so I think I just want to talk about a little bit, like, some of the reasons why this subject is important, why surveillance is important, because I think that sort of sets the tone for why really this whole conversation is deeply important. Obviously, if you care about individual rights, surveillance has enormous implications for Fourth Amendment rights, but also for First Amendment rights and other exercises of individual rights that could be frustrated by people being surveilled by the government. Separately, it's important. Surveillance is important because there are practical effects, or national security sort of surveillance is important because there are practical effects domestically. There are people sitting in jail because they had their communications surveilled under these foreign intelligence authorities like the Patriot Act, and not just for crimes that are related to national security. There are people, who've been prosecuted for food stamp fraud and bank fraud using evidence gathered under these authorities. And then the final one I want to touch on is that surveillance has enormous separation of powers implications, both between Congress and the executive branch and between the government and the people. FISA in general, of which the Patriot Act amended, is really kind of a separation of power statute that sort of set the rules for what the executive branch could do with Congress's blessing in this space. And that deal has sort of been renegotiated over since it was passed in ways that I think we'll get to. And then obviously between the government and the public, if the government can surveil you, that is enormously powerful. So yeah, those are the things people should know going into this, sort of like why we care about this and why we're talking about it today.
Thank you, Carolyn. And for anybody who hasn't worked on these issues for long, it is awesome how many different treasures, if you will, that Carolyn just mapped out. We will get to at least some of them, but there's an interesting story behind, I think, each part of that introduction. Laura, let's turn to you next.
Sure. Yeah, thank you. And thanks so much for hosting this panel. It's really exciting to be here. So I think many of you who are in attendance, I know that I have talked to you also about consumer privacy issues. And I think we often think of these two things as separate, right? Or as separate issues for offices to work on. And I think the one thing that I would want people to think about going into this conversation is that we all know that there's overwhelming consumer concern about consumer privacy and that there's overwhelming consumer support for legislation on consumer privacy. And we also think of surveillance as an issue where there's a lot of support for legislative activity. And I think the point that I would want folks to keep in mind is that these two things are very much tied to each other. And so as Carolyn just talked about, as Senator Udall talked about in the introduction, of course, we are looking at agencies who have been purchasing a lot of information that is available on the commercial market about consumers, collected in one context and then sold and used in a totally different context. And so I think looking back again to what others have said, there is a real opportunity to act here and a lot of appetite to act. And I do think that these two issues are very closely related.
Thank you, Laura. And a point that I'm not sure is made enough. Sandy, can we go to you?
Yeah, thanks. Good morning. Good to see everyone. Thanks so much for organizing this, Sean. I think what I'd like to open with, which I think can be a bit of a challenge at times, but I think it's really important to ground us in, is that law enforcement is not a neutral actor, and it's dangerous to treat them as if they are. Or as our colleague, or more specifically Laura Moy's colleague, Alvaro Bedoya, likes to say, we are all being watched, but some of us are being watched more than others. So, in the framing of September 11th and Patriot, we all understand that Islamophobia was rampant. And as far as Patriot Act specifically, the bill rolled back First Amendment protections that were put in place following the Church Committee when it was revealed that the FBI was spying on and attempting to disrupt the fight for racial justice and the anti-war movement at that time. That opened the door for unjust targeting of a religious community in the United States, or anyone else that was viewed as a threat by the state. I mean, Laura just mentioned the purchasing of data. One of the biggest stories we have seen in this space was the military buying information from a Muslim prayer app. So this is all still very relevant. So I think that we should just keep that in mind, that bias in law enforcement has been there since its creation, and that we have continued to see that play out in very dangerous ways and with new technologies over the past 20 years.
Thank you so much, Sandy. Congressman Goodlatte, one of the great fortunes we have of you being on this panel is that you were around for the Patriot Act passage in 2001, and I'd love to just start us off by talking about that. What was it like? What was 2001 in the Patriot Act like?
Well, Sean, I think it's very important that people put themselves in the context that the Congress was in at that time. This occurred, this bill was signed into law by President Bush 45 days after the September 11, 2001 attacks on our country, which were a surprise attack, much like Pearl Harbor, and the most devastating attack probably since Pearl Harbor. The attack was on primarily civilians, although the Pentagon was also attacked. And so it really shook the country to its core. And the fact that we had not detected this prior to it occurring was very, very concerning to most Americans, and certainly to most, if not all, members of Congress. So legislation came quickly after discovering some of the problems, not all by any means, but some of the problems that occurred leading up to September 11. And the title of the bill is important to put in perspective. USA Patriot Act is actually a very long acronym for Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism, Act of 2001. So that's where USA Patriot comes from. It did address a number of concerns in a wide range of areas. For example, domestic security against terrorism, which we're going to talk about today, enhanced surveillance, anti-money laundering, border security, victims of terrorism, information sharing for critical infrastructure protection, and terrorism criminal law are just some of the many sections of that law. The important thing to understand is that while the law set off some responses to the terrorist attacks, and no comparable attacks have occurred on the United States since then, it also set off a whole host of difficulties related to aspects of the law that were later determined not to be constitutional, that were struck down by courts, aspects of the law that were abused by law enforcement and intelligence agencies and were used in ways that Congress had most definitely not intended. And I think led to a situation that we're in today where each time the Congress attempts to respond, and it comes up in administrations, both Republican and Democratic administrations, activities are uncovered, events shown that lead to concern about whether privacy on the part of American citizens is truly being protected by these important government agencies, and therefore appropriate responses are necessary even today, because over those 20 years, intelligence gathering has changed significantly, and it's changed in response to changes made by the Congress in the law, and they found new ways to redirect their activity. And that's why we are still here today, looking for new ways to hold these agencies accountable and require them to be more transparent in not how they investigate particular terrorist acts, but in their overall approach to this problem. And that has proven to be extremely difficult.
Thank you, Congressman. Carolyn, we just got a firsthand account of 20 years ago. I think you're in a good position to talk to the audience a little bit about what the major trends in surveillance since then have been. And we might be able to open it past the Patriot Act by a few weeks toward 9/11, frankly. Obviously, Patriot Act wasn't the only thing that happened after 9/11. But can you give us, what are the trends that stick out to you over the course of the last 20 years? And I'll flag that you're, no, never mind.
So it's a big question with an enormous amount of nuance that just has to be glossed over for this format. So I just want to put that out there. But the major trend in this sort of national security or domestic national security surveillance that the Patriot Act sort of represents has been there are changes that occur in technology and in the government's need to gather information or to collect information. And then the executive branch will sort of decide what it wants to do, how it wants to respond to these changes. If something's already covered under FISA and the related laws, then they can do it under those laws. But if what they want to do isn't squarely covered, what we've seen is sometimes they will proceed just without a statute at all, or they'll try to sort of shoehorn what they want to do under the existing authorities, which is, I think, some of what Bob was alluding to with the abuse of Patriot Act authorities. Often then programs will be leaked or otherwise revealed, the Snowden leaks being obviously the most high profile of those. And then Congress will come in after the fact and pass amendments to the laws that will often just bless what the government was doing with maybe a little more oversight, or with provisions to add limitations often that the government might have already been doing. So you're sort of just codifying current practice. And then through this process, really these authorities have gotten broader and broader. The most significant, I think, amendment in this past 20 years was called the FISA Amendments Act in 2008. It's synonymous with Section 702, if people have heard of that, which sort of blessed surveillance that ends up gathering Americans' communications with people abroad without any individualized court order, even from the Foreign Intelligence Surveillance Court, which was unusual in FISA until that point. And one thing I want to highlight on this authority is that we have reason to think it impacts a lot of Americans, and the government has pretty conspicuously refused to provide an estimate of that, which is kind of concerning, and I think speaks to sort of this broader trend of greater authority under the statutes for the government to be doing these kinds of collections. At the same time, they've also done more under non-statutory authorities, which historically is kind of unusual. The whole point of FISA is sort of to bring those kinds of activities under a statutory regime. But that sort of agreement has broken down, and now you see the government doing more and more surveillance in the United States or of Americans under non-statutory authorities. So I think those are the two major things I would want to hit on in a 3-minute summary.
It's definitely not enough time, and I apologize for that. But thank you very much for the overview. I want to give Sandy and then Laura a chance to jump in here as well if they'd like to. Sandy?
Yeah, thanks. I think in addition to kind of the very high level national security, IC authorities, I like to kind of ground it a little bit on what was happening in the ground since then too. So one trend that I think that we saw that I think is definitely worth noting, while there has been a strong argument against mass surveillance, particularly around the Snowden revelations, the concept of so-called targeted surveillance seemed to become some sort of compromise. And that gave us programs like the Countering Violent Extremism program, which was an Obama era program, or it's called CVE, which directly targeted Muslim communities and resulted in infiltration of mosques, mapping of Muslim American communities, and other deeply chilling practices. We also saw multiple leaked documents out of the FBI revealing that the agency had labeled Black people protesting police violence as a national security threat. So it was actually a threat assessment, which made up a term using very bad logic and very bad math called Black identity extremists. So again, this word extremist talking about communities of color. And that word extremist creates a suspicion without evidence of any criminal activity that was distributed to state and local law enforcement agencies across the country. So if you can just imagine when you get this document from the FBI, you're like, oh my God, this is a threat. This is a national security threat. So all of a sudden you're looking at BLM protests in your community with suspicion. So I kind of just wanted to point that out. And beyond that, I think it's just kind of increasingly dangerous technologies like facial recognition, aerial surveillance, social media monitoring. These are all being used to target protesters, folks at the border, people across the country from whatever ideology, and really a lack of will from Congress to really address them or regulate their use.
Thank you, Sandy. That's quite sobering. Laura.
Yeah, sure. So I agree completely with the points that were just raised. And I think I would also add that one big trend that we've seen since 2001 also is just an explosion of surveillance technology used not only by federal agencies, but by state and local agencies. Right? So we have 18,000 law enforcement agencies in the country. And many of the troubling problems that we're talking about here, purchase of information about people, really detailed information, purchase of information from apps like Muslim Pro, use of cell site simulators, right? Use of face recognition technology is being purchased, sometimes using federal funds, right? And through a pipeline that feeds federal agencies as well as state and local agencies, and used by agencies, some of whom have even less accountability than some of the federal agencies that many of us are often focused most on. So, for example, I filed a complaint back in 2016 with the FCC about the use of stingrays by the Baltimore Police Department, primarily in Black neighborhoods in Baltimore, right? And this is an agency that was using devices that it had purchased privately with very little oversight or public awareness, using them in ways that disrupted the phone network in that city, and often for things like investigating a stolen credit card, right? Or trying to locate a witness. So, things that you would not think of as rising to the level of seriousness, necessitating such an invasive and problematic tool. And again, disproportionately in Black neighborhoods. So just wanted to raise the point again about the major role played by state and local agencies as well.
Thank you, Laura. That's a very good point. Congressman Goodlatte, I want to come back to you because one, thank you for the 2001 looking back. And since then, what we have is we've had a very interesting 20 years, I suppose. Ultimately, though, I want to know about last year. It was a momentous, big year, and I know you and PPSA were deeply involved. So what do folks need to know? What do folks need to take away from last year, from 2020?
Well, last year, I think, was a year where there was a coming together, a meeting of the minds of a lot of people in Congress beyond the limited number on both sides of the aisle who've always been champions of individual liberty, champions of privacy, protectors of the Fourth Amendment. And we saw that in the fact that the Foreign Intelligence Surveillance Act, three provisions of that act, including a key one, Section 215, dealing with the business records exemption, came up for renewal. It actually expired earlier, but it was extended for a short period of time and then due to expire last March. And that brought everything to a head because some excellent amendments were offered in the Senate, one by Senator Leahy and Senator Lee, that reformed the presence of amici in the Foreign Intelligence Surveillance Court to provide opportunities for basically third parties who are protectors of the American citizens' rights under the law. They don't represent the subject of the warrant that's being sought there, but they represent an independent look at the what's going on, separate and apart from the intelligence agency or law enforcement agency. That passed the Senate with 77 votes. I think 43 Democrats and 34 Republicans voted for it, which is really a remarkable effort to step into a court that operates somewhat out of necessity, but sometimes too much in privacy, to say we need to have a better look inside that court with people who have security clearances, but who are going to look at this from a Fourth Amendment civil liberties standpoint. Secondly, an amendment that would have reformed substantially Section 215, offered by Senator Wyden and Senator Daines, almost passed the Senate. It had, in fact, if every senator had been present, 61 votes, which would have cleared the 60 vote threshold. Two were not present, so they got 59 votes, including over I think around maybe 20 or so Republicans who have not shown up in such numbers in the past. And so those amendments came over to the House. And unfortunately, political maneuvering resulted in the bill essentially being pulled and not brought to the floor. I think, positive result of that is that Section 215 without reform shouldn't have been allowed to continue. And in fact, it wasn't. It expired a year and a half ago. And so, some people celebrated that. But the first question that we at PPSA asked was, well, how is the FBI continuing to operate? How is other enforcement agencies, how are they able to operate without Section 215, which gives easy access to records held by third parties? And we are still trying to get the answers to those questions. We have brought FOIA requests. We have filed lawsuits when we haven't received adequate answers to the FOIA requests. And I really think Congress has an opportunity here to step up in a very big way and hold hearings, some of which can be public, so the public can see what is at stake here, but also some would have to be held in a classified setting. But either way, that kind of oversight is badly needed, and last year set the stage for that and for some of the legislation that we're talking about here today.
Thank you so much, Congressman Goodlatte. And I think those are incredibly important questions. And is it fair to say that the public basically found out about the purchase of records almost contemporaneous to this debate that you're saying, as far as buying records being an issue, a privacy issue? Is that right?
Yeah, I mean, it's sort of been building to a logical outcome because, in September of 2001, Facebook didn't exist. Google was probably in its infancy, so Twitter didn't exist. So a lot of this development of social media and the ability of a whole host of different online organizations to gather information about U.S. citizens was developing in parallel with this whole effort to make sure that as law enforcement agencies gathered information, they were doing it within the confines of the law. And of course, we were finding out that often they were not. So at the same time, I think they discovered, well, hey, we can buy a lot of this stuff on the open market from data brokers. And some have argued, well, you know what, let's let them do that. If private entities can buy the data, why shouldn't the government be able to buy it? Well, there's a huge difference. First of all, there's a constitutional provision called the Fourth Amendment that ought to intercede. But secondly, what the government does when it has the data is very different than what a private business can do. So, for example, the government can imprison you, the government can fine you, the government can regulate you, the government can do all kinds of things with that information that others cannot. And while I'm also an advocate for reform of our privacy laws as they affect commercial enterprises, it's important to me that we address this issue first and foremost, because clearly our Fourth Amendment rights are at stake if you can simply buy the information that the Constitution says you really should have a warrant in order to obtain it.
And with this, I'll point out we can see some of the seeds that Carolyn planted earlier start to grow. I'm going to turn to Carolyn just for the briefest question here. Purchase of data, is it something that statutorily is authorized? Is it in the camp that you kind of described as executive branch figuring out what it wants to do and then we find out?
Yeah, it's the latter.
Okay, thank you very much, Carolyn. All right, so I want to move us up to the next question just because there's a lot to talk about. Congressman Goodlatte, thank you so much. Laura, so we've just heard, 2020. We've heard a little bit about 2001, but for anybody coming into this debate today, we really need to be talking about, of course, the future. So what does being a surveillance reformer in 2021 look like to you?
Yeah, so it's a few things. I think, so one is, we've talked a lot about the Fourth Amendment, and we've talked a little bit about the First Amendment, but I just really want to highlight here that the issues that we're seeing have a real impact on First Amendment activity, right? People who are afraid to use the Muslim Pro app, for example, to find prayer times, and people who are afraid to go to protests because they know that protesters are being monitored. And I think that that will continue to be a big issue in 2021 and something that we really need to be thinking about. Who is being watched and why, and what is the impact on their First Amendment activity as well? I'd also like to highlight that I think in 2021, we need to keep in mind that part of the reason that everything is so off balance, or that we feel that privacy is off balance, is because we've lost our practical obscurity. I mean, it used to be the case that in order to be watched really closely, someone would have to physically follow you and maybe even stop you and ask to see your ID. And with the developments in surveillance technology, that's no longer the case, right? Someone can ID you from afar using biometric technology and can track where you have been and where you are going by accessing location data, either in real time from afar or after the fact by purchasing that location data from another party. And then I'll just highlight again, I know that I've already made this point, but just to rehash it again, consumer privacy here is a real surveillance vulnerability. And I do think of it as a vulnerability, right? No matter how much we think that we are patching up, for example, the Fourth Amendment with cases like the Carpenter case out of the Supreme Court, we are not actually going to be able to protect folks' privacy unless we are patching up this massive vulnerability that is the pipeline of data flowing from the consumer context into the surveillance context.
Thank you very much, Laura. Sandy, I want to give you just a moment, or we can come back to you, but did you want to add anything to this?
I think I just wanted to kind of double down on Laura's first point around the First Amendment, and being a reformer today, it is just grounding this in the national conversation we are having. It's so strange to me when these conversations are had in parallel. We just saw massive uprisings about systemic racism in policing, and we saw legislation to address it. And for some reason, surveillance was left out of the conversation around policing. And I just think that's incredibly problematic. And I just want to ground the conversation in what's happening on the ground and the chilling effects that Laura was explaining.
I'll take a moment to plug CREW, Citizens for Responsibility and Ethics in Washington, actually recently released FOIA documents that showed that the DEA had approved covert monitoring of, I believe, over 50 different instances relative to the Black Lives Matter protests from 2020. That story just came out, I think, last week. Carolyn, I want to turn to you. So coming back, we've gotten this helpful overview. We see some of these other issues that are adjacent or perhaps intrinsically related, but aren't, in some cases are FISA, in some cases aren't FISA. I want to narrow us back in on the Patriot Act. And I'd like you to tell the audience, given what Bob said about sunset, about three authorities sunsetting, what's left of the Patriot Act? And maybe more importantly, what's left of what people think of when they think of the Patriot Act?
Yeah, so I appreciate the way you've framed the question, because there's the, Uniting and Strengthening America, et cetera, Act of 2001, and then there's the Patriot Act. And with respect to the actual bill, the act that became law, most of it is still in the books, either the way it was written at the time, or with amendments since then. But Bob went through the whole list of stuff that was in there, and most of that is permanent. And that includes both communications surveillance authorities, and also financial surveillance and other things that have gotten a little less attention, but are nonetheless very important. And then in terms of the Patriot Act, which I think the public sort of associates just with warrantless surveillance in the United States for national security purposes, as I sort of alluded to earlier, it's only really gotten broader since the Patriot Act, and most of those changes have either been permanent or are always reauthorized. They might technically have sunsets, but there isn't a real expectation that they will actually cease to be part of the law. And then in terms of the bits that have expired, one was an authority that, as far as we know, was never used. One that, as far as we know, was used kind of sparingly. And then there's this 215 authority, which there's still a version of it on the books. It's just with this expiration, it becomes a whole lot narrower. But again, as Bob kind of spoke to, there's reasons to think that a lot of what they were doing under that authority has continued. And one of those reasons is because Senator Burr went to the floor of the Senate and said that they will. So
I forgot about that.
Yeah. So in short, pretty much either way you frame the question, kind of everything is still on the table.
Thank you very much. We have a few more questions. We're running about 3 minutes late, and out of respect for anybody who's got to leave in 60 minutes, I want to underscore, send your questions in now, especially if you're going to leave at 60 minutes flat. We will try to get them asked before then, but we'll probably be on until about 70 minutes in, or 11:35, 11:40. Sandy, I want to turn to you. So you've been doing this for some time, and you have a perspective that I think is really valuable, especially for folks who might be moving around a lot on the Hill. Does Congress's engagement with these issues look different than it used to? And I think that's particularly important given what Carolyn just pointed to, which is our parallel universes of surveillance kind of developing as we discuss this issue.
Yeah, I mean, from my perspective, the way I've seen it changed, I think is like where Congressman Goodlatte kind of pushed out a bit ago with the gatekeeping. Like, I think in the 215 fight, we actually finally saw that gatekeeping model break down. There was a lot of pushback. There was a lot of hesitancy from leadership in both parties and at the committee level to truly challenge, I think, law enforcement and the IC. And it's made for significant challenges in getting real reform. And I think this time we were able to engage voices again in both parties to highlight those voices who had used to be like kind of pushed out. So I think that was a big part of it, particularly voices that are representing impacted communities. They really kind of stood strong this time, and sunsetting 215 was a huge win. I also think even more recently, I think it is worth mentioning the response to January 6th, where we would generally expect an expansion of policing and surveillance powers following such an event. We actually quickly saw a backlash on any new security powers. Like, I think there was some like immediate skepticism there. Like, both the civil liberties and civil rights community broadly coalesced around opposition to any new police powers, arguing that attack had been planned in plain sight and not due to any lack of intelligence. The truth is, going back to the bias, that the threat was not prioritized by law enforcement. For some reason, it was not seen as a legitimate threat, which was a huge mistake. To be clear, I think many in law enforcement now deeply regret that, but that is kind of how it played out. So at the end of the day, I think police have massive resources, and I think we need to be examining what they're doing with those resources and what they're targeting, instead of just kind of, once again, rubber stamping these kind of massive authorities.
Thank you. Congressman Goodlatte, I want to come back to you. So we have staff who weren't here 20 years ago, of course. We have staff who perhaps weren't here 5 years ago. You have a perspective on this that I think we'd all be jealous of. And I'd like for you to just take a couple minutes and talk about if somebody is starting to dig into surveillance for reform now, or their office, their boss is trying to dig into surveillance reform now, where do you think they should start, given the kind of enormous 20 years that we've just discussed?
Well, on this issue, this is a wonderful time to be a staffer in the United States House of Representatives or the Senate, because you can make a big difference, and you can do it in a whole host of different ways. One place that I would start would be to take a look at the document. It's a 4-page document that summarizes a host of the different issues that we've mentioned here today, and specific pieces of legislation like the Fourth Amendment is Not for Sale Act, like a new Government Surveillance Transparency Act that has been introduced, like a piece of legislation dealing with, I call them stingrays, or cell site simulators, that are used extensively, particularly by local law enforcement, to gather information about perfectly law-abiding U.S. citizens who happen to be in a particular place at a particular time. And again, they go around the requirement that you get a warrant before you gather the information. So those devices have a legitimate use. in certain circumstances and with regard to certain people. But that's why we have a warrant process in order to get permission to use them. That's not being followed today, and legislation in the Congress would stop that. And I commend it. So we are working on the finishing touches of that document, which is basically a collaboration of all of the 8 different groups that I cited earlier. And as soon as those finishing touches are put on, we're going to make sure that all congressional offices receive it, but also we'll make sure that those who signed up for this program get a copy directed to them as well, if we may, Sean. I think that's a great place to dig in. You don't have to be on the key committees like the Judiciary Committee or the Intelligence Committee. These bills need co-sponsors from members of both parties, and they need people speaking up and saying and telling their constituents what they're doing to protect their constituents' civil liberties, their rights, their protection under the Fourth Amendment.
Thank you very much, Congressman. So I have 2 more questions for the panel, but to the point I was making earlier, we want to try to get Q&A, especially for anybody who has to leave within 60 minutes. So I've got 2 that we're going to turn to now. I'm actually not sure who should handle this first one, so I'm going to read it out loud and invite the panel to jump in. Can you go over FISA Section 702 and expectations for its upcoming reauthorization, I should say. I don't know if anybody wants to jump on this. I think either Carolyn or Congressman Goodlatte, you'd be my first that I'd think of, but whoever wants to tackle it, please do.
I'll defer to Carolyn.
So, yeah, so I described Section 702 earlier, but just to refresh, it's used for gathering communications without individualized warrants between often people in the United States and outside the United States, including Americans. And it's one of these authorities that has to be reauthorized every 5-ish years, I think is usually the sunset. And now it's coming up again for reauthorization.
In December 2023, for anybody who's not aware. So, but these fights tend to be multi-year long. So that would mean the discussion is starting. Sorry, Carolyn, please.
Yeah, and so we should expect reform ideas to start coming to the fore relatively soon because it is such a long reauthorization process. I think the last time it was reauthorized, it became a pretty dicey legislative debate. And I think because surveillance doesn't break down easily along partisan lines, there's a lot of people who care a lot about it in Congress on both sides of the aisle, and it can be difficult to cobble together the coalition necessary to pass something. And I think we can expect to see that again, that there will be not a simple path to reauthorization, I guess.
Sean, if I could
Carolyn.
add to that, Carolyn makes a very good point, but it's also important to note that while Section 702 is a very important provision in the law dealing with gathering intelligence about foreign nationals, some of whom may be a threat to the United States, incidental information is gathered when a foreign national would communicate with a U.S. citizen. And some fear that sometimes it's even the monitoring is done of the foreign national in hopes that they will get information about a U.S. citizen. So these potential abuses need to be very carefully examined, and what's being done with that information, and there are rules for retaining it and so on. All of that needs to be reviewed and, in my opinion, reformed. But in addition, 702 is an opportunity for people to those bills that we're talking about today that may or may not get accomplished by the time Section 702 comes to the fore, when time limits on it put a lot of pressure on. That's an opportunity to make sure that as we reform 702, some of those other things are reformed at the same time as a part of a package. So it's I think, a really important opportunity, but let's not wait until December 2023 on these issues. Let's start that debate on 702 now and continue the debate on these other pieces of legislation that have reached their prime already and are ready for action.
Thank you, Congressman. And both the questions that we got are very good. I'm going to read the next one out loud. It's a little bit longer, but I think it's a great question, and I'm going to leave it open to the panel to jump on top of, and then we'll return to our regularly scheduled questions. Regarding Title I of FISA, which governs the Foreign Intelligence Surveillance Court, the FISC, Andy McCarthy and the Wall Street Journal editorial board have argued recently that Congress should just abolish it and keep the decision-making here, as in within Congress for oversight and within the administration for deciding whether or not to conduct the surveillance. If Congress was to abolish the FISA court, do you believe this would stop abuse of American civil rights or exacerbate the problem? It's a great question. I'm going to give preference to Laura and Sandy, but I think Carolyn and Congressman Goodlatte, this is a great thing for either of you to opine on.
I think one thing I would want to say, that is a good question. One thing I think is important to know in this context is that the Supreme Court has not conclusively said what the Fourth Amendment, how the Fourth Amendment bears on intelligence investigations conducted in the United States. In some sense, FISA was intended to kind of provide a statutory answer to that question, and it has succeeded so far in avoiding having the court answer that question of what the Fourth Amendment says in this context. And so if you just get rid of Title I of FISA, we don't really know what the constitutional landscape is that we are like thrusting ourselves into. And I don't know which way that sort of necessarily how it should make us feel about the proposal, but I think it's just something important to know about the proposal.
My instinct is that we would slide back to where we were before FISA. And while the court has a number of issues and things like the Leahy-Lee amendment, which would put more representation into the court from basically civil libertarians with security clearances who can go in there and make sure that the court gets the best advice about whether the rules are being followed by the law enforcement and intelligence agencies is an important feature. I hear what the argument is on the other side, but I just fear that Congress is way too overloaded with way too many responsibilities. And there are so many tens of thousands of cases that go through that court that the kind of oversight that would be conducted would not be satisfactory. And while and clearly, as we found from some of the audits by the Inspector General of the Justice Department, clearly the court's oversight has not been satisfactory. I think giving up on one source of oversight in favor of going back to what, quite frankly, Congress had and continues to have and never seems to be able to successfully use as fully as it needs to is not a good idea.
I think that
I think
tend to agree with that as well. Yeah, and the FISA court was considered a strong safeguard following the Church Committee. I don't think we want to lose it. I think the concern is more secret interpretations of the law and secret court opinions. I think that is very troubling. So I think that we need additional oversight. The court cannot be a rubber stamp, but I don't think that would be helpful, just eliminating it.
Thank you, Sandy and Congressman Goodlatte. I'm going to actually there's a follow-up question to this, and I'm going to send it Carolyn's way. I hope that's okay. But I also wanted to use it as an excuse to kind of dive in, because Carolyn, earlier you mentioned that FISA is kind of a separation of powers statute, which I think is an incredibly interesting way to look at it. I actually think it's quite accurate in most respects. I'm curious if you think that applies here, but I'm going to put that on your radar and read the follow-up question, and you can respond to either, both, or neither. So the follow-up is, if the FISA court had to deal with the Fourth Amendment aspects, does that mean that this type of collection domestically would require an open hearing? And I'm just reading this follow-up. Yeah, this is either in the context of a Title I warrant under, for instance, the FISA court, or an administrative decision to conduct surveillance that I guess somehow end up in a court. So again, open to anybody. Carolyn, I think you might be best positioned to answer this.
I mean, to the extent we're trying to determine what the Fourth Amendment says in a non-criminal intelligence investigation in the United States, the answer is we don't know yet. Someday the Supreme Court may tell us, but they've so far been presented sort of obliquely with that question and kind of left it open. And so it's difficult to say.
Difficult to say. A little bit of uncharted territory. I don't know if anybody else wants to jump in. I'll just pause for a couple of seconds. Okay, hearing nothing. To the person asking the questions here, to the people who have asked questions, I hope those do answer the questions. Anybody who has more, please send them in. We will get to more at the end of this, and I'll just put out there that we will be in touch. So anybody who's listening to this panel, if I can serve a role in putting in touch with any of these panelists, I'm more than happy to. The conversation doesn't need to stop here. Okay, with that, going back to the regular programming, Laura and Carolyn, I kind of want to go back to this discussion, this kind of visualization of what we should expect in the near future. What is the trajectory of surveillance? In other words, if nothing happens in Congress soon, what do you think happens next nationwide?
Yeah, so I mean, I think we've already highlighted on the panel that there are urgent problems here that are just going to continue to grow, right? I mean, there is a booming data broker industry, and agencies are really big customers, both at the federal level and at the state and local level. And so we can anticipate continued growth of that, as well as widespread acquisition of some really invasive surveillance tools that we've talked about. Representative Goodlatte was talking about stingrays, and I was as well, and aerial surveillance, face recognition technology, social media monitoring, right? These are all really invasive tools that are being used at multiple levels of government. And the harm is real. There's an impact on First Amendment activity, as we've already talked about. And so now is the time to act. And I think Representative Goodlatte put it well when he said that this is a great time to be working on these issues, because there is bipartisan support, both for greater surveillance oversight and for greater consumer privacy protection. So without action, I think these problems are just going to continue to intensify and become more entrenched. And but it's, luckily for us, perhaps, there's a ton of opportunity here, and it's a good time to act.
Thank you very much, Laura. And Carolyn, I think I wanted to get your thoughts in this too, although I certainly invite Congressman Goodlatte and Sandy to jump in afterward as well, if they'd like to.
Yeah, so I think everything Laura said is spot on. I would maybe add a little like Tic Tac of Hope, in that Sandy alluded to this earlier, that there are institutional pressures leading towards more data gathering and consolidation and processing. But at least when it comes to surveillance questions that do make it into the political sphere, you're seeing more pushback, I think, than obviously you saw in the post 9/11 era, and even for a number of years after that, more pushback, especially from the public, but also from members, against at least codifying greater authorities. I don't know how far that gets us, but it's no longer sufficient, and polling, I think, kind of bears this out. It's no longer sufficient to just raise the specter of national security and kind of get what you want if you're the executive branch. It seems they have to work a little harder. So maybe that is one countervailing force against this kind of otherwise overwhelming pressure, it seems like, towards greater data gathering.
I have to admit that it does seem a little bit different than it used to, at least when I started working on these issues. Yeah, I'm a big fan of Tic Tac of Hope. I think that's clearly the Halloween candy to give out. If anybody has that on the stores, we could all use some Tic Tacs of Hope. All right, so I'm going to start wrapping us up because we're a little bit over time. Once again, thank you to everybody who joined. Thank you to everybody who submitted questions. But really, I'm going to invite the panel to send us off. Similar to how we started out with one thing you should know going in, I've asked all of the panelists to prepare one thing they want you to take away from this discussion. It could be from this discussion, could be general. And I'm going to start with Sandy and then go to Carolyn and then go to Laura and then go to Congressman Goodlatte to wrap us up finally. So Sandy, please, one thing you think that people should be, the most important thing you think people should be taking away from this conversation.
Yeah, thanks, Sean. And thanks so much for hosting this and to everyone for the conversation. I've enjoyed it. But yeah, I think for closing, I think I'd like people to be aware of the blurred line between national security and policing. For people who care about surveillance, the ICC is absolutely pressing and urgent. But there's also the issue of police interacting with people on the ground that needs to be addressed. I would like people to understand that those issues are they're both separate and they're related. We all know that the FBI had a file a mile long on Martin Luther King because he was considered a massive national security threat. You know, things like Black identity extremism are just the most recent iteration of that kind of surveillance.
Thank you, Sandy. Carolyn.
Yeah, I think the one important thing I think to take away is that decisions about surveillance, about who can gather data and how and under what oversight and circumstances are being made day to day. And for the staffers in the audience, or even if you're, members of the public, if decisions are being made by other actors in the system, mainly by the executive branch, and then by companies, by state and local law enforcement. And so there is no, staying on the sidelines is not a neutral position. It is a decision to allow other entities in this sphere, which have different incentives and different sets of stakeholders and values, to make those decisions. And that doesn't necessarily, maybe that is your preference, but it's important to know that that is a decision to stay on the sidelines is a choice.
Carolyn, I feel like the next panel, we could probably spend an hour on decisions that got made because Congress didn't decide. I like that. Laura, I want to turn to you.
Yeah, so, and I'll just echo the thanks for hosting this and for the conversation. I guess this could feel like an overwhelming and sweeping conversation, right? We've talked about so many things in the course of the past hour and 5 minutes. And so I think that the point that I would highlight for folks who are looking at these moving parts and moving pieces and feeling overwhelmed is that there are so many opportunities here, right, to act. There is the Fourth Amendment is Not for Sale Act that others have mentioned, right, that aims specifically to target this pipeline of data from the commercial context to surveillance. But, there is legislation that could and perhaps should be done on data brokers, on location privacy, on mobile device privacy, on cell site simulators, on biometric privacy, on the privacy of consumers on advertising exchanges and on social media, right? Social media monitoring, we talked about that. Not to mention, of course, comprehensive privacy, comprehensive consumer privacy, right? So there are just so many opportunities here to target and carve off pieces and start going after them. There's a lot to be done and many opportunities to lead. Thanks.
Thank you, Laura. I think that was very well said. And just in case there are people who feel overwhelmed by the subject matter here, whether from this panel or more generally, hopefully this panel's done you all right, but we were all there for whatever it's worth. These are not easy issues. These are not even easy issues on a solution basis or on the problem side. So, thank you for the diligence. I would say that it is rewarding. You will be happy that you learned it if you do, if you don't already know it. Congressman Goodlatte, thank you so much again for joining. I want you to basically sign us off. You are our last commentator. We don't have any questions in the hopper, so after this, unless one comes in, that will be the end of the panel. Congressman Goodlatte, please.
Well, Sean, again, thank you to everyone for participating. Thank you for those who have stuck with us through this program. I agree there's a lot to absorb here, but I'm going to abuse my privilege and say that there are two things I want to leave you with. The first one is that while this is a complex issue, it's an extraordinarily issue for every member of Congress and their key staff people to engage on, rather than to leave this to the courts, the executive branch, and a whole host of other actors who are abusing this process. So Congress must engage. Secondly, I do not believe that you have to make a choice between your security and your civil liberties. You have the opportunity in this country to have a very high degree of safety and security and a very high protection of your civil liberties. But that balance is not there right now. And so I don't think any of you should hesitate to step up and take a close look at these bills. The Fourth Amendment is Not for Sale Act, introduced in the Senate by Senator Wyden, Senator Paul, Senator Lee, Senator Leahy, a whole host. I think there are maybe close to 20 sponsors of that bill now in the Senate. It's been introduced by Chairman Nadler of the Judiciary Committee in the House, and looking for co-sponsors on both sides of the aisle. Congressman Ted Lieu and Congressman Tom McClintock have introduced the bipartisan Cell Site Simulator Reform Act, the Stingray bill I referenced earlier. There's still an opportunity to either attach to other legislation or have a standalone bill for Lee Leahy that puts the amici in the FISA court in a stronger way, and a half dozen other bills that will send you information on our 4-page document, but time doesn't allow me to describe them all. But my only request is that if this is in your portfolio of issues, move it to the top and engage. This is a really great time and a great opportunity to look into an issue that I think you'll find to be quite interesting when you look at all that has been going on in the 20 years since the USA Patriot Act was signed into law.
Thank you so much, Congressman Goodlatte. Thank you, Laura, Sandy, and Carolyn. It was an honor having you all on the panel. I really appreciate the discussion. To the audience, thank you so much for joining. I hope it was helpful for you as well. We will follow up with materials. I think all of us are available to you if you want to follow up anyway. And that's it. Thank you very much for joining. Good luck on whatever is next in your day.